Hello everyone, welcome back to my channel Aspire TGPSC. Hope you are preparing well for the exams. In the series of videos that I am uploading, this is the second video and the topic is fundamental rights. Now without further ado, let's get to the subject. Fundamental rights. Fundamental rights are enshrined in part 3 of the Constitution from the articles 12 to 35. They are derived inspiration from the Constitution of USA, that is the Bill of Rights. They are regarded as the Magna Carta of India and they are justiciable, that is we can move to Supreme Court for the violation. They promote the ideal of political democracy. Originally there were 7 fundamental rights and present there are 6 fundamental rights. The original fundamental rights were right to equality, Article 14 to 18, right to freedom, Articles 19 to 22, right against exploitation, Article 23 and 24, right to freedom of religion, Articles 25 to 28, cultural and educational rights, Article 29 and 30, right to property, Article 31, right to constitutional remedies, Article 32. Right to property was deleted by the 44th Constitutional Amendment Act 1978 and it was made a legal right under Article 300A. Now coming to the features of the fundamental rights, some fundamental rights are available to citizens while others are available to all, that is citizens, foreigners, legal persons, including the corporations or the companies. They are not absolute but they are qualified, which implies that the state can impose reasonable restrictions. Most of them are available against arbitrary action of the state. Most of them are negative in character and limitation on the state, and while some are positive which confer privileges on the persons, and they are justiciable, move to the court for violation. Next, they are defended and guaranteed by the Supreme Court. They are not sacrosanct or permanent. The Parliament can curtail or repeal them by the Constitutional Amendment Act and not an ordinary act without affecting the basic structure. They can be suspended during operation of national emergency except Articles 20 and 21. The 6 rights under Article 19 can be suspended only during war and external aggression. That is, they cannot be suspended during an internal emergency. The scope of operation is limited by Articles 31A, 31B and 31C. 31A is saving of laws, providing for acquisition of estates, etc. 31B is validation of certain acts and regulations included in the 9th schedule. 31C is saving of laws giving effect to certain directive principles. Next, application to the members of the armed forces, paramilitary forces, police forces, intelligence agencies and analogous services can be restricted or abrogated by the Parliament, which is under Article 33. The fundamental rights are restricted while the martial law is in force, Article 34. Most of them are enforceable while few require parliamentary law. Now the definition of the state is under Article 12, which states that the state includes the following, that is the Indian government and the Parliament, which are the executive and legislative organs of the state government. Central government, the government and legislature of the states, which are executive and legislative organs of the state government, all the local authorities, which include the municipalities, panchayats, district boards, improvement trusts, etc., and all other authorities, which include statutory or non-statutory authorities like LIC, ONGC, SAIL, etc. Next is Article 13, which is the doctrine of judicial review, that is the laws which are inconsistent with or in derogation to the fundamental rights shall be declared void, and this power is conferred on the Supreme Court by Article 32 and on High Court by Article 226. Next, the definition of law in Article 13 includes the following: permanent laws, which are the laws made by the Parliament or the state legislature; temporary laws, which are the laws issued by the President or the Governor; ordinances; statutory instruments, which include the order, bylaw, rule, regulation, notification; Non-legislative law, that is custom or usage having the force of law. The constitutional amendment is not a law and it cannot be challenged. The Supreme Court in Keshavananda Bharati case 1973 held that constitutional amendment can be challenged on the ground that it violates the fundamental rights. Coming to the first one, that is the right to equality. Article 14 says that the state shall not deny to any person equality before the law or equal protection of the law within the territory of India. It includes legal persons. Equality before law is British origin and equal protection of laws is American Constitution. The Supreme Court held that the rule of law is a basic feature of the Constitution. It is not absolute. It has some exceptions which are as following. The president and the governor enjoy certain immunities. They are not answerable to any court. No criminal proceedings can be initiated against them. No process for arrest or imprisonment can be issued, and no civil proceedings can be initiated. Next, Article 361A, which is no person shall be liable to civil criminal proceedings for proceedings in either house of the parliament or house of the state legislature. Article 105 is no member shall be liable for any vote given by him in the parliament or any committee. Article 194 is no member shall be liable for any proceedings for vote given by him in any legislature or any committee. Article 31C is an exception to Article 14, which provides that the laws made by the state for implementation of the directive principles contained in Article 39 Clause B or Clause C cannot be challenged on the ground that they are violative to Article 14. Immunity to the foreign sovereigns, ambassadors or diplomats, and immunity to the UNO and its agencies. Next, prohibition of discrimination on certain grounds. That is Article 15, which provides that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, and it implies of only state. The words discrimination and only are given in this specifically because discrimination means to make an adverse distinction with regard to or distinguish unfavorably, and the word only connotes that the discrimination on other grounds is not prohibited. The second provision of Article 15 says that no citizen shall be subjected to any disability, liability, restriction or condition on grounds only of religion, race, caste, sex or place of birth, which applies both to the state and individuals. There are three exceptions to this article of non-discrimination for the general rule. That is, the state is permitted to discriminate and make provisions for women and children. It can make provisions for socially or educationally backward or SC/STs, for educational institutions, and for admission to the educational institutions, including the private institutions, whether they are aided or unaided, except minority educational institutions. And the last provision was added by the 93rd Constitutional Amendment Act 2005, through which the Central Educational Institutions Reservation and Admissions Act 2006 was enacted. And the concept of creamy layer, it includes 7 categories which will not benefit from the quota. That is, the persons holding constitutional posts like the president, vice president, judges of the Supreme Court, High Court, members of UPSC, state public service commissions, CAG, CEC, and so on. Second category are Group A, Group B, or the Class 1, Class 2 officers of all India central and state services, employees in PSUs, banks, insurance organizations, universities, and private employment. Third category are the people in the rank of colonel and above in the army, equivalent post in the navy, air force, paramilitary. Fourth category are the professionals like the doctors, lawyers, engineers, artists, authors, consultants, and so on. Fifth category are people engaged in trade, business, and industry. Sixth category are people holding agricultural land above a certain limit and vacant land or buildings in the urban areas. that is the sixth category, and seventh category is whose gross annual income is 6 lakhs and above. They do not come under this quota. Next is the equal opportunity in public employment, which is Article 16, which provides for equality of opportunity for all citizens in matter of employment or appointment to any office under the state. Again, there are 3 exceptions to this, where the Parliament can prescribe residence as a condition for certain employment, and it can provide reservation for appointment in favor of any backward class if they are not adequately represented, and they can provide an office related to law related to an office for religious or denominational institution or member for the governing body belonging to that particular religion. The Mandal Commission, it was appointed in 1979 by Morarji Desai government, which was the second backward classes commission in terms of the Article 340. It submitted its report in 1970 and it identified 3743 castes as socially and educationally backward. In which they constituted nearly 52% component of the population, excluding the SC/STs. The commission recommended for reservation of 27% government jobs for OBCs and other total reservation. They have totaled up to 50%, and it was after 10 years in 1990 the VP Singh government declared reservation of 27% government jobs for OBCs. Again in 91 Narasimha Rao government introduced 2 changes: preference to poorer section among OBC in the 27% quota and reservation of another 10% jobs for poorer, that is economically backward sections of higher caste, which was not covered by any existing schemes. In the famous Mandal case 1992, the scope and extent of Article 16 Clause 4, which provides for reservations of jobs in favor of backward classes, has been examined thoroughly by the Supreme Court, and the court, though it rejected additional quota of 10% for poorer section of higher caste, it upheld the constitutional validity of 27% reservation for OBCs. Next is the abolition of untouchability, Article 17, which abolishes untouchability and forbids its practice in any form. In 1976, the Untouchability Offences Act 1955 has been comprehensively amended and renamed as the Protection of the Civil Rights Act 1955. The term untouchability has not been defined either in the Constitution or in the Act, and the Act declares 7 acts as offences, which include preventing any person from entering place of public worship, justifying untouchability as a traditional religious practice, denying access to any shop, hotel or places of public entertainment, insulting a person belonging to SC on the ground of untouchability, refusing admission to hospitals, educational institutions, hostels, preaching untouchability directly or indirectly, and refusing to sell goods or services to any person. Next is the abolition of titles, Article 18, which prohibits the state from conferring title, prohibits citizen of India from accepting any title from foreign state. Foreigner holding office under state cannot accept title from foreign state without the consent of the president. Citizen or foreigner cannot accept present or emoluments under the foreign state without the consent of the president. Next comes the right to freedom, which has the protection of 6 rights, which include the right to freedom of speech and expression, assemble peacefully and without arms, associations or unions or cooperative societies, move freely throughout the territory of India, reside and settle in any part of the territory of India, practice any profession or to carry on any occupation, trade or business. Earlier, it had 7 rights, and through the 44th Amendment Act of 1978, 7 rights have become 6 rights, where right to property was repealed and it was made a legal right. Next comes the protection in respect of conviction for offences, Article 20, which has 3 provisions: no ex post facto law, no double jeopardy, no self-incrimination. Ex post facto law is no person shall be convicted for any offence except for violation of law in force at the time of commission of act, not subjected to penalty greater than be prescribed by the law in force at the time of commission of the act. No double jeopardy means no person shall be prosecuted and punished for the same offence more than once. No self-incrimination is no person accused of any offence shall be compelled to be a witness against himself. Right to protection of life and personal liberty, Article 21. Right to education, Article 21A. In this, 16 to 14 years of age is prescribed. It was included by the 86th Constitutional Amendment Act 2002. Even before this amendment, the Constitution contained a provision for free and compulsory education for children under Article 45 in Part 4, Directive Principles. Next is the protection against arrest and detention, Article 22, in which the detention is of two types, punitive and preventive. Punitive detention means punishing a person for an offence committed by him after the trial and conviction in a court, whereas preventive, on the other hand, means detention of a person without trial and conviction by a court. Next, right against exploitation, prohibition of traffic in human beings and forced labor, that is Article 23, in which the traffic in human beings includes selling and buying of men, women and children, immoral traffic in women and children including prostitution, devadasis, slavery. Next is the prohibition of employment of children in factories, etc. Article 24, where it has prohibited the employment of children in factories and other hazardous places below the age of 14 years, but it does not prohibit harmless innocent work. Right to freedom of religion, freedom of conscience, free profession, practice and propagation of religion, Article 25, in which right to propagate does not include the right to convert a person from one religion to another. Right to freedom to manage religious affairs, Article 26, which protects the collective freedom of the religion. Freedom from taxation for promotion of religion, Article 27, which states that a fee can be levied but a tax cannot be imposed. This fee is levied for the purpose of providing certain services and safety measures. Freedom from attending religious instruction, Article 28, in which 4 types of educational institutions are given, which are wholly maintained by the state, administered by the state but established under endowment, recognized by the state, receiving aid from the state. These are the 4 types of educational institutions. Cultural and educational right, protection of interest of minorities, Article 29, in which any section of citizens who have distinct language, culture, script can be protected. No citizen can be denied admission in educational institution. Right of the group and individual is protected by this. Protection to both the religious and linguistic minorities. Right of minorities to establish and administer educational institutions under Article 30, in which the right to establish and administer educational institutions. Compulsory compensation has to be provided. No discrimination in granting aid, only to minorities. Minority educational institutions are of 3 types, whose recognition and aid is by the state. Only recognition and neither recognition nor aid is from the state. Next is the right to constitutional remedies, Article 32. Dr. B.R. Ambedkar stated that an article without which this constitution shall be nullity. It is the very soul of the constitution and the very heart of it. Supreme Court described it as a basic feature of the constitution. There are 4 provisions where we can move to Supreme Court. Supreme Court can issue directions or orders or writs. Parliament can empower other courts. And Article 359, which is where the President can suspend the right to move to any court for enforcement of fundamental rights during a national emergency. The Supreme Court is considered the defender and the guarantor of the fundamental right, and they are the original and wide powers of the Supreme Court. The Supreme Court under Article 2 and the High Court under Article 226 can issue the writs of habeas corpus, mandamus, prohibition, certiorari and quo warranto. It is borrowed from the English law where it is called as the prerogative writs. Now, the Supreme Court can issue writs only for fundamental rights, and the High Court can issue writs for fundamental rights and legal rights, where the jurisdiction of writ jurisdiction of the Supreme Court is narrow and the High Court is wide. The Supreme Court can issue the order against any person or the government anywhere within the territory of India, which is a wide writ jurisdiction, whereas the High Court can issue only within the territorial jurisdiction, which is a narrow one. The Supreme Court, it is the fundamental right, and for High Court it is discretionary power of the High Court. Next, habeas corpus writ, which is literally means to have the body of. It is a Latin term. It means that it is an order issued by the court to a person who has detained another person to produce the body of the latter before it. It is regarded as bulwark of individual liberty against arbitrary detention. It is issued against public authorities and private individuals as well. It cannot be issued if the detention is lawful, if it is contempt of court, when it is issued by the competent court, and if it is outside the jurisdiction of the court. Next, mandaments literally means we command. It is issued by the court to a public official asking him to perform his official duties that he has failed or refused to perform. It cannot be issued against private individuals to enforce departmental instruction that does not possess statutory force, when the duty is discretionary and not mandatory, to enforce a contractual obligation to against the President of India or the state government and state governor, and against the Chief Justice of High Court acting in judicial capacity. Next, prohibition. Prohibition means to forbid. It is issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Unlike the mandamus, it directs inactivity by the higher court to a lower court. It is issued only against judicial and quasi-judicial authorities. Certiorari literally means to be certified or to be informed. It is issued by a higher court to a lower court to transfer a case or to quash the order of the latter in a case. It is issued on the grounds of excess of jurisdiction or lack of jurisdiction or error of law. Unlike prohibition, which is only preventive, certiorari is both preventive as well as curative. In 1991, the Supreme Court stated that it can be issued also for administrative offices. So at present it includes judicial, quasi-judicial and administrative. Next, quo warranto, which means by what authority or warrant. It is issued to inquire into legality of a public office. It cannot be issued for ministerial or private office. Unlike all other writs, quo warranto can be filed by any interested person other than the aggrieved person. Armed forces and fundamental rights. Article 33, it states that it empowers the Parliament to restrict or abrogate the fundamental rights of members of armed forces, paramilitary forces, police forces, intelligence agencies and analogous forces. The objective is to ensure proper discharge of duties and maintenance of discipline, and the power to make laws under this article is given to the Parliament. It cannot be challenged in the court. Under this, the Army Act 1950, Navy Act 1950, Air Force Act 1950, Police Forces Restriction of Rights Act 1966, etc. were enacted. Martial law and fundamental rights. Article 34. It provides for the restrictions on fundamental rights while martial law is in force in any area within the territory of India. It cannot be challenged in court. This concept was borrowed from the English common law, and the term martial law is not defined anywhere in the Constitution. Next, affecting certain fundamental rights. Article 35. It lays down that the power to make laws to give effect to certain specified fundamental rights shall vest only in the Parliament and not in the state legislatures. In this direction, Article 35 contains following provisions. Article 16, which is the residence for the employment. Article 32, empowering other courts to issue orders, directions and writs. Article 33, restricting fundamental rights to armed forces, police, etc. Article 34, indemnifying the government servant for act during the martial law. The Parliament shall make laws for punishment with respect to two articles, Article 17 and Article 23, which is untouchability and traffic in human beings and forced labor. And it remains in force until it is altered or replaced. The present position of the right to property, originally it was under fundamental rights, and the obligation of the state was to pay compensation. Through the 44th Amendment Act 1978, the Article 19, Clause 1, Clause F and Article 31 were abolished from Part 3 and inserted Article 300A in Part 12. It is not a basic structure of the Constitution and it is not a fundamental right but a legal right. It can be regulated by the Parliament. It protects private property from regulative action. The aggrieved person can move to Supreme High Court under Article 226. It is not a guaranteed right to compensation. In Part 3, there are two cases for the right to compensation, which are Article 30 and Article 31A. Article 30 is inserted through the 44th Constitutional Amendment Act 1978 and Article 31A through the 17th Constitutional Amendment Act 1964. The exceptions to fundamental rights are 31A, 31B and 31C, which were discussed earlier. Now the criticism to fundamental rights are that they have excessive limitations. There is no social and economic rights. There is no clarity, no permanency, suspension during emergency, expensive remedy, preventive detention, no consistent philosophy. Significance of fundamental rights are that it is a bedrock of democratic system. Conditions for material and moral protection of man, formidable bulwark of individual liberty, establishment of rule of law, protect interests of minority and weaker sections, strengthen secular fabric, check absoluteness of state authority, foundation stone of social equality and social justice, ensure dignity and respect, participation in political and administrative process. Now, rights outside of Part 3 are constitutional rights, legal rights or non-fundamental rights, which are Articles 230, 265, which is no tax shall be levied or collected except by the authority of law. Article 300A, which is no person shall be deprived of his property save by authority of law. Article 301, which is trade, commerce and intercourse throughout the territory of India shall be free. Article 326, the election to Lok Sabha and the state legislative assembly shall be on the basis of adult suffrage, which are equally justiciable and move to High Court for their violation. Now I have covered most of the parts in detail from the Indian Polity textbooks. There are certain tables which are given in this topic. It is important to go through them as well, which are martial law versus the national emergency, and which articles are applied to the citizens and which are applied to the foreigners except the enemies. So please go through them once. Also please go through the articles 12 to 35 in detail once. Also please practice the previous year's questions and mock tests. Please don't forget to like, share and subscribe to our channel for more such informative videos. I'll be sharing the videos more often from now, and stay tuned for my next video. Hope this video was helpful for your preparation for Group 2, Group 3 and other exams as well. Thank you for watching. Have a nice day.